December 9th, 2024. We're going to call a Cultural Resource Review Board meeting for December of 2024 to order. I will start with roll call. Robert Olson.
Here.
Janet Jordan.
Here.
Steve Newman.
Here.
Susan Sheldrup.
Here.
Blair Knighting, absent. Dr. Leslie Keys. And I am present, Nick Jonahakis. Great. Let me read the civility clause. Do we have anyone on the phone? Okay. And the public notice. The Cultural Resource Review Board serves as an advisory board which makes recommendations to the Board of County Commissioners. This is a properly noticed public meeting held in accordance with requirements of Florida law. Members of the public will be given reasonable opportunity to be heard on propositions before the board as those items are addressed on the agenda. For public comments on matters not being considered by the board today, a general public comment period will be provided to address the board on matters within its jurisdiction. Each person addressing the board shall limit comments to 3 minutes. Persons shall not address the board or any member thereof unless specifically recognized by the chairperson to do so. Once recognized, members of the public shall address their comments to the board as a whole. Public comment is intended for the board to hear from the public and shall not be considered an opportunity to demand immediate response from the board or its members. Board members shall not engage in dialogue with persons making public comments unless the question or comment is directed through the chair or made with permission of the chair. We do have some public hearing items on the agenda. Is that correct? Actually, they're all internal, so there's nothing public on the agenda today?
Nothing to vote
There's
on.
no action items.
Right.
Very good. Okay. So let's, I'd like to open up the floor for a general public comment for items not on the agenda. From any of
They
the,
did one.
Huh?
They did one.
Okay.
yeah, we did take a roll call.
Okay. Staff was put on the record.
I'd like to
Oh, I
make a
don't know.
motion
Yes.
that, from Susan Sheldrup, that on each agenda, we have a running tally of the status of the issues that we have recommended to the commission. Nothing long, just like to know what happened to certain things that we have recommended and we haven't heard back. So if we could have a running tally, no discussion would be needed. It would just be helpful to see what's happened.
Is that part of the staff reports typically?
Yes.
But you want the summary on the front page, is what you're saying?
Starting from January of each year, just a quick approved by the commission or approved with recommendations or rejected, something like that.
I'll second the motion.
Okay, let's take a vote on it. So the motion has been made to have a staff report item summary on the front page of the review board meeting.
Through the chair, for clarification, it doesn't have to be on the front page. You're going to be under a section that says staff reports.
Okay, so we could do that. Yeah, I mean, there's always a staff report section,
Correct.
but so we could have a summary there. Would that be satisfactory? Let's take a vote.
Starting just from January of each year, or some.
You do an annual report, so, but I understand you want this to be a tally, and so it would be under the staff section of the agenda, not necessarily on the front page as stated.
Yeah, but some of the items that we recommend have time-sensitive reactions, so that's, I think, would help.
I don't understand that statement.
Well, for the ad valorem tax exemption, when it goes from us to the commission approves it in a first step basis, but for actually to be implemented, there's a legal time limit. The work all has to be completed and approved and done for the owner to get that state ad valorem tax exemption. In other words, if it's 12 months, 24 months, there's a time frame, and that would help us know if things are moving forward, because after they go through us, we don't necessarily get reports back from how they're going, through building permits and growth management and all that. Does that make sense?
So you're asking for
Status, almost.
I understand, but I'm just saying, not necessarily staff would have access to all that information, so I'm just trying to figure out what work is being directed to staff, if work, which shouldn't be directed to staff,
Well, and in that case, that is something that goes to staff.
not building permits.
The growth management will review stuff for the ad valorem tax exemption as it's going through, because I know they're doing one now.
Right, well,
They're doing Barn College.
but you're talking about building permits, those go through the building department.
Okay.
Or Chair, may I be recognized?
Yes.
Another example would be our comments on the 5-year comprehensive plan.
If they were forwarded to the board, okay, understood. Just trying to make sure, because it was on the first page, so we just want a staff report under the staff section, okay.
All right, do we need to vote on it?
So this is each meeting, not annual?
Each
I mean,
meeting, correct.
The in composite could be annual?
Correct.
Okay, good.
Yeah.
Okay.
So basically it's just an update.
Yes,
Yeah.
Okay,
don't want things to go into
fine, let's go ahead and vote on it. Robert Olson?
Yes.
Janet Jordan?
Yeah.
Christine Newman?
Yes.
Susan Sheldrup?
yes.
Lear is out. Dr. Keys?
Yes.
And Nick John Hack is yes. Okay. So that passes, and we'd like to see a staff report updated summary at every board meeting, every 2 months. Thank you. Any other public comments for items not on the agenda? There's really nothing, no public items on the agenda. So I know Ms. O'Hara, you just walked in.
Yes.
Any public comment?
I'm good, thank you.
Okay. All right. Very good. The next is the approval of meeting minutes from October 14th, 2024, and subsequently November 12th, 2024. Let's start with October's meeting.
I think the only thing I noticed is I thought Blair was absent then because she made the comment that she would be absent again in December. I mean, when we were scheduling this meeting, she said, oh, I'll be absent again. And this is just me being picky, but all the way on the
Well,
last
she is
page.
showing absent.
Oh,
Were you
well,
looking at the
then,
November?
okay,
You were looking at the
I have,
November.
I guess, a different set of,
Yeah, you're looking at November, I think.
my agenda also says August 12th minutes, so I don't know what's going on there.
Well,
Anyway,
to clarify, so we're addressing the October 14th minutes?
Correct.
And she is noted as absent there,
okay.
so there doesn't need to be a change.
Correct. She was absent, and
Okay.
then we approved the meeting minutes from August 12th. Because there was a bypassed month.
I'm just saying the stuff that I was emailed is not what the other one is.
I thought you didn't get them by email.
No, I got them this morning by email,
Okay.
and that's,
Were they different than what's here?
I'm not sure, I'm sorry, I
That's
didn't
okay.
do due
I just want to
diligence.
make sure, so there doesn't need to be a change.
Anyhow.
It says approval of minutes from August 12th. That is correct. Because we approved the August 12th minutes
In
during
October.
the October meeting. Oh, you're showing it in December. Okay.
anyway, okay, as long as the paper copies have been corrected, that's
Yes.
great.
Yeah, this is the correct.
Um,
so.
All right, then how about the last page of the minutes that you guys have? Has it got my name spelled right or wrong? How's that for being egotistical?
Where is it?
Almost at
Under,
the very end.
under staff reports.
Yes.
Which bullet point is it? Keeping up.
Did you highlight?
Hang on. See, I got them all trying. It's, under staff reports, what mine shows is the Florida Black History Museum final report is available.
Is this for the October minutes? It's totally different.
I know. It says October 14th, but on the top of the minutes it says August, so that's why as long as she's correcting you guys, the stuff that I got this morning apparently was not.
All right. So I will, so you are looking at something different. I don't think there's any issues with any of these. Are any other comments? Do we have any other comments on Monday, October 14th?
Yeah, I don't, when did the minutes come in? today?
I requested them this morning so that I could read them before I got here, and apparently what I have is not what you guys have on paper.
I don't show any minutes.
Yeah, I couldn't find
Could you
any.
confirm they were submitted with the agenda? So that we can-
I know that.
I thought we did.
Oh,
Were they or were they not?
I'm pretty sure they were. I was copied on that.
So they were copied on the agenda, but if they were not received, there are physical copies, and if we need to postpone for verification, you may postpone that vote.
If we postpone this one, we will remember the
I'm
process.
not sure, Ryan. Yeah, I'm still new.
We
Okay.
could do that if you guys want, if the group here wants.
Well, how many people read them?
I read them here.
Yeah, I read them electronically, and that's the problem.
Just today?
Yeah,
Okay,
I
yeah, I
mean, I
think I
requested
got
them
them.
today,
Yeah.
because I didn't
Yeah.
find them in an email.
That's fine, you
They're
can
next
move that
to
item to the next meeting.
copies. Or later in the meeting, and I'll read them, if that helps. I'm trying to find a copy.
Oh, they're down here.
There'll be plenty of reading time during my presentation.
I've got one from the November.
That's from November.
Other people will have.
This is the agenda from today. So yeah, we're one copy short for the October.
Borrow one.
You can read this.
So, look at the share.
All right. So the next item is the November 12th, 2024 special meeting minutes. And there were some agenda items that were addressed by the board. If you did not get those today, those we could review really quickly because most of those were for the recommendations to the land use requirements. So there are two items. I don't see why we can't read those out right here so we can approve those. And then we'll have a little bit of time for you to review
Okay.
what you review. Agenda item number 1 back from November 12th was Mr. Robertson explained the process behind Inspire board commenting. Hasn't done an overhaul since 2002. Mr. Olson asked about the practicality of approved processes, where certain protected areas begin and how development impacts protected areas. He also asked about signage along roads and protected areas along the county's roads, trails, and scenic highways. Karen Taylor explained signage from a planner's point of view. Mr. Olson spoke about the Robinson PUD, inquiring about the process of a CRAS and the logistics behind the scene of reviewing PUDs. Item 1. The next item was Mr. Ganahakis gathered Dr. Keys and Newman's comments from A1.4 for the entire document. They noted that wherever the word historic is mentioned, that we should replace an add with historical, archaeological.
And it should have an A in the archaeological. We're not doing it the way the parties do it. ARCH, archaeological is the way the professionals spell it. Yep. Thanks.
Okay.
I don't have an extra copy.
Just to get together.
So now we need to make sure that archaeological is done the way that
Professional archaeologists spell it.
there are 2 accepted spellings.
Right, but
Yes.
unless you work for the federal government here, you spell it AE.
Yes. And that goes back to the 1960s when the Parkies became their preservationists.
Right, so could we note that to the,
It's just a
The
global
draft.
change. Yeah.
so archaeological is spelled ARCHAEOLOGICAL?
Yes.
Okay. Dr. Keys proposed for the county to carry out public education activities to be added in A1.5. Dr. Keys inquired what the Crrb evaluation connotes in terms of tax exemption. Mr. Mount answered that for the recent ordinance for the tax exemption that followed due to the state updating their ordinance, for section C1.4 historic housing, replace historic resource review board, and any future references with CRRB, County Resources Review Board. Replace the word housing with the word building. For section E1.6, Ms. Newman proposed that archaeological sites should be added in next to historically significant sites. Dr. Keys proposed that TDRs, transfer development rights, needs to be spelled out. She also proposed that the new economic development director should be invited to the next CRB meeting. For section E.2.2.6, Ms. Sheldra proposed that the specific species under the section be clearly stated. However, the listed species would be dozens of pages, and because they, and just to kind of add to that from this, because they are listed, we decided not to do that. Okay. For section E.2.4, Mr. Lagasse dispersed handouts at A1.3, which outlines future land use policy. The right to submit a comp plan amended as a property owner is vital. Ms. Knighting and Dr. Keys emphasized that additional signage is needed to properly allow the public to know that they exist so that they can take advantage of programs and trails. Dr. Keys suggested that we look into the role of environmental specialist as it applies to ensuring that GLC grant money is being properly allocated. There was discussion of the artifacts, antiques, and collections in the county building. CRRB members want to write a recommendation for the comp plan to have an updated staff description for the role of cultural liaison. Ms. Newman will draft a document regarding curation. Has that happened, Ms. Newman?
I turned in a short document
Okay.
to the county.
Very good. The 2050 draft comp plan will be presented at the routine December 5th Board of County Commissioners meeting. And did that occur?
It did.
Okay, thank you. We were adjourned at 3:24. Any comments or corrections to these?
Could we do CRAS, spell it out too? Just because I don't have any idea what that stands for.
Sure.
Crass is probably not what it means.
What does CRA stand for?
Cultural Resource Assessment Survey.
Thanks.
Can I ask a quick clarifying question through the chair? At what stage do you want that spelled out? Like, are you just saying generally when you see it and
Yeah, well,
presented to you?
anytime that you've got an acronym, it's just still more courteous to spell it out.
So you want that corrected in the minutes? I'm just trying to verify exactly what you're asking.
Because anybody else that goes to read it won't have any idea what they're.
Understood, thank you.
Yeah, it's typically style is you use the full
Yeah,
term or name or whatever, and then you put in parentheses
the acronym.
behind it
Yes.
the
Understood.
acronym,
Just-
and then you can use the acronym, any other reference to it in the text you're doing.
Thank you. Just wanted to make sure I knew what you were talking about. Thank you.
And I did read the other minutes.
Any corrections on the other ones? You think we're okay?
Yeah.
All right.
Just use the English spelling acknowledgements to the Americans. I don't want you to look at it or mean it. We need a motion, don't we, to approve both of them?
We do. Could you make a motion?
So through the chair, my suggestion is you take them one each at a time, since there are
Yeah.
changes that will have to be noted.
Yep. All right. So I guess I'll make a motion to accept the, let's talk about the November 12th minutes
Sure.
first, since we talked about those, as they are revised. And let's take a vote on it.
So
If the only thing that was revised,
through the chair, so it's going to be a motion to approve, not to accept. And
I'm
then,
sorry.
as I understand, the revisions are to the spelling of archaeology and spelling out the acronym CRAS.
correct. So I will make a motion to approve the minutes.
A second,
Is he allowed to make a motion as the chair?
Yes.
Okay, thanks.
Okay, so let's take a vote on it. Mr. Olson?
Yes.
Ms. Jordan?
Yes.
Ms. Sheldra?
yes.
Ms. Newman?
Yes.
Dr. Keys?
Yes.
Nick Jarnakis, yes. Blair Knight is absent, so I have signed these and have them over to you. So the next, did anyone want to take a look at these minutes before? Okay, let's do that, and then we can vote for these at the end, is that okay?
Sure.
Okay. This is,
That's for,
Those are from
That's for
October
October.
14th. That's meeting where we ask for the special meeting.
And while we do that, you can take your time. I think we can do it after the presentation. We'll talk about it at the end. That's okay?
Sure.
The next item are the approval of the current agenda items. And the agenda items are as follow. We have Sunshine Law and Ethics presentation by Office of the County Attorney by Ms. West. There's officers election, number 2. Number 3 is the Florida Division of Historic Resources. And Dr. Keys is going to talk to us about special category and smaller matching grants. He's going to give us an update. And there's a staff culture review, resource review refresher. It's a presentation and no vote is required. Let's take a vote on the agenda.
So, through the chair, since item number 3, the Florida Division of Historical Resources, that was not on the published agenda, I just want to note for the record that it is being added and it can be added by vote.
Okay, so the first item we're going to vote on is if we approve the addition of the Florida Division of Historic Resources since it was not on the draft agenda. Let's vote on that item.
We need a motion and a second.
Yes.
I move to approve the addition of that on the agenda.
Okay. Let's vote on it. Mr. Olson?
Yes.
Ms. Jordan?
Yes.
Ms. Newman?
Yes.
Ms. Sheldrop?
Yes.
Dr. Keys?
Yes.
And I will also say yes. Nick Hernandez. So, the motion to add item 3 has been made, voted, and approved. So let's now vote on the revised approval of the current agenda.
Move to approve the agenda as modified,
Amended.
amended.
I'll second.
A second.
All right. And let's vote on it. Mr. Olson?
Yes.
Ms. Jordan?
Yes.
Ms. Newman?
Yes.
Ms. Sheldrop?
Yes.
Dr. Keys?
Yes.
And I'll also have a yes vote. So the approval of the current agenda as amended, well, the approval of the current agenda is approved. Approved. All right, and with that, I'll turn it over to Ms. Keely West.
Let's see how far that mouse works. Good. So, good afternoon. My name is Keely West. Most of you know me. I am a senior assistant county attorney in the Office of County Attorney. Today we're going to talk about sunshine law, public records, and then I'm going to talk briefly about voting issues. This is a fun topic for all involved. It is, I saw Ms. Newman laugh. It's serious, however, it can be as interactive as you choose it to be. I don't want to just throw information at you, but I know you haven't had this training in a while. If you have questions as we're going through, please feel free to stop me when the question pops into your mind and ask then. And I'm happy to address it to the best of my ability. So, just so as this disclaimer, so portions of the information in this presentation, mostly for the sunshine and the public records, is from Pat Gleason, who is in the Office of the Attorney General. She is the guru with regard to sunshine law and ethics and public records. If you have any questions, I'll have her contact information. But we are using part of her presentation. So, Florida's government in the sunshine provides a right of access to government proceedings at the state and local level. It applies to all equally to elected and appointed boards. Some people think that it's not applicable to an appointed board, but it is. And so this board is governed by the sunshine. Sunshine law is under Chapter 119. Meetings to the public boards and commissions must be open to the public. So there's a 3-pronged test to make sure that you're in compliance with the sunshine law. That the meeting is open to the public, there has been reasonable notice of such meetings, and that there's minutes of the meetings are taken. Those are the 3 things. You check those 3 boxes, you are in compliance with the sunshine law. As we all know, it can be a little bit more difficult than that. If it was that easy, I wouldn't have 10 additional slides.
What's reasonable notice?
We're going to get there.
Wow.
So, I'd like to lay it out first and then get into some details. So, who's covered? All public agencies in the state, advisory boards and committees such as yourself, private companies doing business on behalf of a public agency. In the case of you were to hire somebody out or contract somebody out to do one of your historic surveys, all that information and everything they had, all those meetings would also be required to be under the Sunshine Law, as well as public records. One person acting on behalf of a public agency, members and members-elect of a public agency. Sometimes, as you know, we just had a transition of our Board of County Commissioners, and there was a point of time where they weren't county commissioners yet, but they were elected as county commissioners. The minute they became elected, the Sunshine Law applied to them, so they couldn't have meetings with other commissioners, seated commissioners, unless they were publicly noticed, open to the public, and then meetings were taken. There's no definition of a meeting, any gathering of 2 or more members of the same board or commission to discuss some matter on which foreseeable action will be taken by the board or commission. Normally, foreseeable action is something within your wheelhouse, something within your expertise that will come before you. When it's an advisory board such as this, it's a little bit easier to define as opposed to a board or county commissioner, because let's be honest, anything can come before them for a vote. So it's a lot broader. However, you know that if Dr. Keyes and Ms. Newman are talking about a potential landmark, well, that could come before this board. They could discuss it, but again, public meeting, notice, minutes.
If we're talking about a Christmas party, well, okay.
Right, yeah, so there. And it doesn't have to be a formal meeting. You don't have to be in the same place. It can be written correspondence. It can be telephone or electronic communications. Or it can be used intermediaries or third parties. That's why sometimes we'll send out an email and we'll say, do not reply all. Because that reply, if you reply all, will be considered a sunshine meeting. And again, notice, public place, minutes. You're not from discussing board businesses with staff or non-board members. Those individuals may not be used as a liaison to communicate information between the board members. For example, a board member cannot ask staff to poll other board members to determine their views on a board issue. If Mr. Sheldrick had come to Brian and said, hey, I'm thinking about making a motion to add staff reports, can you get a sense of what the other board members feel? That would be using that incorrectly. Not that you did that, I'm just trying to use current examples. Yeah, this looked like I was. So if you were to do that, so you can't use your staff as a go-between.
What if you are just wanting staff to distribute information that's already out there publicly?
Yes. So they can hand out information as long as you're not asking to get what's your feedback on the information, do they think we should move forward with this? In any way trying to circumvent the fact that this would eventually come for the board and it's the board decision.
Yeah.
Okay.
Now, National Register nomination, for example, already approved by Washington, I would sent to.
Sure, absolutely. Dissemination of information is fine
Okay.
if there's no impending decision on that information. So you can't circumvent the Sunshine Law by delegating the authority to act on its behalf to a single member or to a staff person. So basically, if you guys have the ability to approve COAs and you were going to say, you know what, we can't all meet, we're going to let Ryan do that, it's a fair delegation, but then Ryan would have to act in the sunshine the same way you would have to act in the sunshine, if that makes sense. Right now, we're going through a hiring process in the county to hire a new county attorney. There's going to be a committee to do that. Since that committee was delegated that authority by the Board of County Commissioners, that committee has to operate in the sunshine. They're just staff people. They're not elected or appointed, but since they were delegated the board's authority, they now have to act in the sunshine. Fact-finding information gathering is okay. So you can go out and do trips, you can go look at things, you can do some fact-finding. Inaudible discussion or passing notes between board members may be a violation of the sunshine, even if it occurs at a public meeting. I can give you case law on text messages. I advise that text messages are public records, and we'll talk about that a little bit later. But yeah, even that passing of information. So here we go, Dr. Key's office. Must be given reasonable notice of meetings that are subject to the law. So guess what? Reasonable is not defined. Yeah, so we try to make sure that we have things in a timely manner. So like when I noticed the agenda wasn't published, just to make sure, we went ahead and did a proper motion to add it. So you want to have reasonable notice. Usually it's anywhere from 3 to 7 days. 10 days is ideal to publish those meetings. You can have other meetings in emergency situations, but it must be sufficient to inform the public. So we have websites, and we publish a lot of our meeting notices on websites, which is kind of that instantaneous age that we live in, but we still like to have them up there 3 to 7 days before the meeting. So there is no time, but it is, reasonable.
If the agenda is sent out as draft, then we should not consider that.
We're going to work on that process some, so I think when it comes out as draft, it just depends. I wasn't concerned with it was draft, if it remained draft, but when I look on the website and I see the agenda, it didn't have that item on it. So
Yeah.
for the record, to have a clean record, I just wanted it added to the agenda, and that's normally what you would do.
Okay, because I just have been using electronic copies, but they're not the same as what they.
Right? And that's something I think staff is willing to work on, and we can get there with that, so I agree with that. Let me find my page here. Okay. So reasonable notice, again, not defined. We have time frames at the county, generally 10 to 7 days. What do we try to publish the agenda? Well, the meeting notices go out. We do those yearly because you're kind of a set board, but if there's a special meeting, as you had in your last one, we go ahead and make sure we get that on the website about a week ahead of time. Public participation. So even though it's not one of those three things, it has to be a public meeting. So that means that the public has to have a right to be there. The public has a right to present and be heard at meetings where decisions affecting the public are being made. Not absolute. We have rules in the county. You know some of those rules. You hear general public comment. We require you to be civil. We require you to have decorum, and we require you to speak for 3 minutes. And so that's in your bylaws. That's in the county's board rules and policies, and that is just the general rule. Different places may say 5 minutes. Different places may say, I've seen places where you speak on items the board before the board actually takes action. It doesn't have to be at the same meeting. Sometimes if it's a controversial thing, they may have a meeting just for public comment, and then at the following meeting they take their action. So it doesn't have to be at the same meeting. Generally here in the county it is. We talked about that. We adopt policies, so we have our policy. Rules and policies, they're time guidelines. We have procedures for representatives of groups or fractions to address the board or commission at meetings in which a large number of individuals wish to be heard. So if we had a very controversial item here at the CRRB, we will probably adopt those rules. And basically, is if they have a group of people they want to represent, we allow them more time. So it's in our rules and policies. So normally it's 3 minutes. But if they have 10 or 12 people, don't quote me on that number, I'm not sure, and they sign, I waive my time to that individual, we will give that one person 15 minutes to represent the whole. And then I think if it's like 20 or more, it's 20 minutes. And so that's just for time efficiencies and not hearing repetitive arguments from the same 10 people will get up and say the 10 same thing, as opposed to one person could more articulate under 15 minutes. People can come in here and videotape, they can tape record, and they can photograph all of these meetings. And we do designate a specific period of time for public meetings, for public comment. There's no exemptions to the Sunshine Law. Only that can be done by the legislature, must be passed by 2/3 majority. And it can't be broader than necessary. The only time I've had that since I've been in Florida is with the COVID, where they had to make changes because you couldn't meet in public. And so there were some other mechanisms they allowed to be used, in order to have the business of local governments continue. And so, you had to be on Zoom, but you still had to offer public comment. And I was in quite a few Zoom meetings for the public comment. Took a while for people to figure out how to do that without having total disruption in getting, I forget what the word was, but they got a lot of spam in their public comment. That's not the word I'm looking for, but they got crashed. It was like a party crasher, so it was a little disruptive. But anyway, so that's very rare. You'll sometimes hear, do we have to have a quorum? You have to have a quorum. You have to have 3 people when you're present in this room to conduct business at all times. People can call in, other board members can call in, but in order to have the meeting, you need to have 3 people present in this room.
May I ask a question?
Yes.
Okay.
You can tell me if I'm talking too fast.
No,
too.
it's great. The issue of voting, we brought this up, I think, the last time around. We had a quorum in the room, but only the people in the room can vote. You can't vote online. Is that accurate, or was that inaccurate?
You can vote
Not online, I mean remotely.
on the phone, yeah. So, and this board's a little bit different. So this is a 5-member board. I just got looks. Wait a second. You have 5 regular members and you have 2 alternates. So that's how your quorum is only 3. This is a 5-member board. So you have 5 regular members, 2 alternates. Your 2 alternates only vote. So if I have 5 members and one's gone, then I can use an alternate. In theory, that's how these boards work. That's how your bylaws work. That's how the rules and procedures work for the Board of County Commissioners. And so you have 5 members with 2 alternates. 2 alternates only vote in the absence of a regular member.
We should probably know who those alternates are. since we've
I'm
been
looking at our list.
Yeah, they're
too,
on the
for
list. I
doing
think.
a roll call for everybody.
Well, the roll call is fine for everybody. We recognize that the quorum is 3. So yeah, they're all here. The roll call is to identify who's here. Your roll call identifies everybody in the room, staff, everybody included. So yeah, but you need 3 for quorum. So that's how the voting works. I don't know what happened at the last meeting. This is not the only board that has that, and it does get a little bit out of whack. Generally, the only time we have concerns is if it's a 2/3 vote requirement and stuff like that, but we'll get that worked out for you. But just for the record, so you know, under your bylaws, you're a 5-member board with 2 alternates. And I think Ms. Newman knew that because at one point you were an alternate and got moved up to a regular. And so that sometimes is the confusion. Yeah. And so I think sometimes that's what happens. I think you came on as a regular member right away, or maybe. And so that's something that's done not by the staff here, that's done by our office of their Board of County Commissioners. And so they're working on getting that worked out. Very strange setup here at the county. I'm not used to it in other jurisdictions where I've worked, that you have this alternate thing. And I think part of it is sometimes it's hard to get people in the seats and get people here. And so that's just kind of a backfill mechanism.
So who are the alternates?
I don't see them articulated on this list. So we have the at-large might be the alternates?
Yes, the
That's-
2 at-large
So
are the
that's
alternates.
Janice Jordan and Ms. Sheldrick.
Yes, yeah, so those are our 2 alternates.
So, do I infer that the rules of procedure for the commission are exactly the same as for this board?
Nope, not all the time. You have your separate bylaws. I'm going to go over bylaws at the end. I have a copy of the bylaws for everybody.
Okay. And a citation to them?
It's on the bylaws I'm going to give you.
Well, since we're, since we're talking about alternates,
Yes, sir.
we're going, next item is election of officers. Can alternates be elected?
They can. There's no prohibition against it.
Okay, thank you.
There's no prohibition against it. That's why I say, so alternates is a very strange concept. The idea was to just get backfill in case they're absentee. We don't have that much issue anymore, but most boards do treat it as a 7-member board. The only reason I wanted to clarify that is because since you are a 5-member board, that's why the quorum was only 3. If you were a 7-member board, the quorum would be 4. And the quorum is stated in your bylaws. So I'm just trying to clarify. I'm sure Dr. Keys had figured out I was off by a number because of 7. Exactly. So I wanted to clarify that.
Will you advise how to change those rules of procedure?
So the bylaws can be true, well, I don't think that will change because the makeup of the board is set by the Board of County Commissioners.
So how is it changed?
The Board of County Commissioners would have to change it.
Through a motion or
No,
recommendation of this board?
Yeah, you could go talk to them and ask them if they were willing to change it, but the boards and commissions are set by the Board of County Commissioners.
Okay, so if I understand you correctly, you're saying that even though I might spend 20 hours reviewing documentation, I would have no vote unless one full member is not present.
Correct.
Does that sound fair to you?
I'm not here to advise on the fairness of it, that's the process. That's the process, and it's important that we, have alternates for when someone is missing. I think generally we allow the votes to continue because, it depends on the subject, but I think the fairness is, that's just the rule of the Board of the County Commissioners. I can read you. I can find that part for you and send you a copy of it.
Thank you.
Yeah. Alternates are appointed to assist the board committee with meeting quorum requirements to conduct business. It is essential that alternates make every effort to attend all workshops, regular and special meetings of the board and committee, as an alternate may be called upon at any time to serve as a regular voting member. Therefore, it is also important that alternates have the most current knowledge of ongoing discussion of matters that carry forward from previous meetings in the event such vote must occur. So there is a section this is the rules and policies of the Board of County Commissioners, and so that is in there. I'm happy to send you that as well, but it is also mentioned in your bylaws.
Thank you.
Okay. Violations. So if you ever have an instance where there's a violation of the Sunshine Law, the action is void ab initio, which in other words, it's not legally valid from the time of its inception. The violation cannot occur, if public comment, so in other words, if somehow public comment was overlooked or not had, that is not considered a violation. And that's by statute, not by policy. And you can cure a violation of the Sunshine Law, let's say, wasn't a properly noticed meeting, you went ahead and took action, made your vote, you can cure that by independently them publishing the item, publishing the meeting, coming back and doing it again. Penalties for violation of Sunshine Law, unintentional, there's fines. So a knowing violation, there's fines, it's a misdemeanor, a fine and 60 days, suspension or removal from office, payment of attorney's fees and course. Obviously, that's when two members decide to have discussions about something they shouldn't be discussing outside of a publicly noticed meeting. So generally, that's not for if there's just an inadvertent or not published of something. That's generally when you just have two members of a local government type of committee that are conversing when they shouldn't converse on a decision that's going to come before them. It's to make entire decision-making process open to the public. Yes. And so when in doubt, assume the Sunshine Law applies. So if you're already going down the wrong path. Any questions about the Sunshine Law? Pretty straightforward. Your minutes are taken by staff. Go ahead.
For the process of one person kind of absorbing other people's time, does that group of people need to be present? So let's say you have one candidate that's speaking for 15 minutes on behalf of and for 10 people. Do those 10 people need to be present?
No,
Okay.
normally not. The rule is a little bit vague in that area, but generally we allow that because a lot of our people, they don't have time to come. And so as long as we'll get a clear indication of name, address, and that they're actually, we have a form for it, and that they're ceding their time to that person. And so there's
Thank
that. Mm-hmm. Any other questions about Sunshine Law? Delightful.
I assume that minutes.
Doctor, I know Dr. Key, I'm waiting.
Well, I've testified
Uh-huh.
numerous times. 'Cause. So the minutes should reflect what happened, the comprehensive, what happened, 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 what hap actions and discussions.
There's no discussion on the length of the minutes or how the minutes have to be done, just that there are minutes. So normally we try to reflect the vote. We don't do a verbatim. I mean, we obviously, whenever you have a quasi-judicial matter before you, which is like your COAs or your landmarking, those are quasi-judicial. If there's going to be an appeal of that or an issue with that, the person appealing needs a verbatim transcript. That's why we have a recording. But that's why also we try to have what I like to call the clean record. We know who's speaking, we know who's in the room. That's why when we do roll call, we like you to acknowledge by voice, because then if somebody has to go back in and transcribe that tape, they know whose voice is whom. Over time, we know everybody's, like when I listen to the tape, I know who's who. But a lot of times if there's a transcription from a tape recorder, we'll hear female voice one, and that's how it will be referred to throughout. Or the transcriber will note it as that. And so the transcript comes from there. The meeting minutes, there's no exaction on how those have to be done. We do like to record the vote, but we always have the tape to fall back on.
Difference in different states.
Different
Different
states,
cities,
different
actually.
cities, different local governments. Our local government, when we do our public comment transcription for the minutes, we don't put everything that was said, only that the person gave public comment. If we even do that now, I'm not sure. I know there's debate about that right now. We did it one way before, then we changed. So yes. But there is no defined thing. And the only thing about meetings you should note too is that when they say open to the public, it has to be a public space accessible. So, you know, I've had the situation where you guys, not you all, just hypothetically, are going to have a lunch and have your meeting at a lunch. Well, that's a public space, but is it really accessible? Because people have to pay to get in there to have food and things like that. And so you have to be cautious with that. Most of our meetings are convened here. I think we had a conversation once about maybe going to visit a structure or something like that and kind of having your meeting there. And that was fine. We just needed to make sure it was a space open to everybody, accessible to everybody. And that you could do that if you, what's the house up on,
O'Brien.
is that the O'Brien
Yeah, that was the last one we talked about, way down south.
Yeah, so you wanted to go there, and you can do that. We would notice it for that location as long as it's a public space, and you could go in and do that. So you can also do site visits, information gathering. You can do that on your own. You can do that in conjunction. The one thing I hear a lot is we can only talk at this meeting. That is not true. If Dr. Keys and Mr. Olson want to have a conversation about bylaws or a project coming up, I'm not giving any hints, by the way. I'm not saying that. I shouldn't have said that. I apologize. I apologize to staff. If you wanted to have a conversation about that, you would just have a publicly noticed meeting. You would say that Dr. Keys and Mr. Olson are meeting regarding the Crrb bylaws. They're meeting in the permit center room, and minutes will be taken. So it doesn't have to be this, all of you. You can do that, and then others can attend if they so choose to attend. But anyway, so that is it for Sunshine Law. Moving right along to the next exciting topic I have today, Public Records Act. So Public Records Act, Chapter 119, Florida statute, provides the public a right of access to records of state and local governments. Dr. Key is going to ask me what a public record is. I'm going to get to that in a couple slides. As well as access to records of private entities acting on behalf of the government. Remember, our surveyor, who was commissioned by this county to go out and do work on your behalf, would have to keep those records as public records. All of those records. To inspect records is constitutional right. Article 1, Section 24A of the Florida Constitution has the right to inspect, are specifically included within the scope of this provision. Florida is unique in that it has both as a constitutional right and a statute. Not every state has that. And quite frankly, Florida was one of the first to have a Florida Constitution regarding sunshine. Section 118.0012 defines public record to include all documents, papers, letters, maps, tapes, photographs, films, everything, regardless of the physical form. and means of transmission made or received pursuant to law or ordinance in connection with the transaction of official business by any agency. So, all the papers, everything you see here laid out on this table, all this is public records, except for personal notes. If you're taking personal notes, those are not public records, unless you somehow take those notes and transcribe them into a public record. But personal notes are not public record. As interpret this definition to encompass all materials made or received by an agency, agency being the county, agency being this board, in connection with official business, which are used to perpetuate, communicate, or formalize knowledge. So it's everything, all documents, papers, and emails. This can even include non-final email documents. So the draft agenda is a public record.
That should be confusing.
It's not. I mean, we keep them. We retrieve. We have record storage like you wouldn't believe. But yes, those are public records. Some are not public records. Personal notes used to prepare other documents, strictly personal emails or other personal writings, things of that nature. Notes given to you by someone else. You should assume that all of your records, everything you use in conjunction with this board, is a public record.
I am going to ask you a question.
Okay, I'm ready. I'm doing the best I can.
Vendors.
Vendors.
I am actually in another project serving as a county vendor. They told me I don't have to keep anything but turn in a final report through procurement. I was dumbfounded. I said I would still keep everything I generate.
So the county would keep what you sent to it, but other than that, not necessarily. It depends on the nature of the contract.
Okay.
It depends on the nature of
Sending
the
me to do
contract.
research.
Huh?
They will. I'm doing research on other Black History museums, but I will write a report, but they don't
Right.
care about any of the other documents that get generated. I just was surprised that I don't have to keep.
It depends on the nature and the capacity in which you're working for the county. It depends. But if you're just an independent contractor, that's a yes or no sometimes depending on the scope of the work.
Okay.
Can I ask you a question to follow up on that? A request is made of a vendor directly. Are they in jeopardy of violating that law with our liability? Do you see what I'm saying? So if Ms. Keys is the vendor and she says, no, I'm not going to give you that, are we now in violation, or does the record have to come through us? The request have to come for our liability?
So it depends. And so the record would, so if she's required through her scope of work to maintain public records, which should be in her governing document, then she has, but if, she would have to retain them.
Yeah.
And then when we ask for them, so sometimes we have certain things where we say, we put that caveat in there, public records, and then we say, you either have to, at the end of your contract, you either have to maintain those public records for the records retention period, or you have to, if you don't choose not to retain them, then you have to give them to the county. And so there's different ways that could occur. And so sometimes if they chose to retain them, when we get a public records request, we will go to the contractor and say, please provide these public records.
Okay, thanks.
And in my case, I've been told I don't need to keep them and I don't need to provide them to the county either.
Okay. And that's the scope. It depends on, because is the contract with the county?
Yeah, it's purchase order through procurement is the way it's done, but
So purchase
Only
orders
ones
are a little
that
bit different than,
final
yeah, purchase orders are a little different than contracts where you're actually doing work. And so that's just requesting, that's like buying a goods. And so we're buying the report.
okay,
Okay, so there are some distinctions.
very weird.
I'm not trying to avoid it, I'm just saying.
And I'm keeping everything.
Yeah, that's fine, yeah, that's always a good policy. But there are other mechanisms. Okay, maintenance of records. Pertaining to agency business must be maintained in accordance with public records retention laws. We have schedules, we have GS schedules that tells us how long we keep a record. Is it a land use record? Do we have to keep that for 5 years? If it's a deed, we have to keep that in perpetuity. So there's these whole things. If it's fire rescue and it's their 911 dispatch log, we have to keep that for 7 years. If it's fire rescue and it's the not the dispatch log, but the record of report, those get kept for a different amount of time. So there is a records retention schedule. Unfortunately, the county's kind of they're so fearful, they're like, we're gonna keep everything forever, and that adds up. Anyway, so any of your emails sent to county staff are already being maintained for compliance with public records law. Agency-related records not sent to county staff should either be maintained by the board member or forwarded to staff. My suggestion is always, when I have an advisory board, send it to staff, let them retain it. So if you don't send stuff, so you'll have to provide it later. Penalties for violating, very similar. Fines, you get a $500 fine, a first degree misdemeanor, $1,000 fines. And these are generally when you have someone who destroys a public record. We've had instances, not here at the county, other places I've known, where there's been text messages and someone has willfully destroyed those text messages in violation of the Sunshine Law. And so, as long as you're not destroying records out there, you should be fine. If you ever have a question about whether something is a public record, you can always reach out. Office Attorney General has, so there's some resources for Sunshine Law and public records. There's a Government in the Sunshine Manual, First Amendment Foundation, and then the Office of the Attorney General. So that is it on public records. Other than we're a little bit concerned about Dr. Keyes keeping things. Other than that, does any other records? Any other questions?
Will this be made available on the website?
No, I can send it to you though.
Okay, thank you.
Okay, I'm going to go over a few ethics things. I'm not doing a whole ethics presentation because I know you have your elections and other things to do today, and you're probably getting tired of hearing my monotonous voice. I do want to talk about a couple things though. One is voting conflicts, because we've had this come up a couple times. So you may not participate in any manner on any matter that would inure to your special private gain or loss. So if you're going to benefit either financially or some other way, you may not participate in any manner. There's some exceptions to that on depending on what your goal is in participating. And this means any principal by whom you are retained. So if you work for a company, if you have a parent organization, or if you have a relative or business association. So if any of those people are involved in any matters before this board, you have a voting conflict. Voting conflicts are yours to determine, not mine. I can help you, but at the end of the day, you have to decide if you have that conflict. You have to publicly state the conflict prior to the vote, and then you have to file a written disclosure. So there's two ways you can deal with a voting conflict. One, you have to always disclose them. And this is the form. We give you this form. This is how we do it. It applies to elected officials. There's a different standard. And then there's appointed officers. And then your disclosure. So looking at appointed officers, you have to abstain from voting. You are not prohibited from otherwise participating in these matters. However, it depends on how you do your disclosure. If you intend to make any attempt to influence the decision prior to the meeting at which the vote will be taken, you must complete and file the form before making the attempt to influence the decision. Okay, so what does that mean? If I have an item before this board, and I sit on this board, we already know I have a voting conflict. I can't vote on my own item. So I can't vote. No matter what happens next, I can't vote. However, if I want to somehow present to you, tell you information, give you facts, give you a presentation, before that meeting, I need to fill out that form, and it needs to be circulated to all of you. So you know that I, one, can't vote, but two, I am going to attempt to influence your decision by doing a presentation. If I don't want to do that, if I don't want to do any of that, all I have to do is say on the record, I have a voting conflict, I will file my form within 15 days. So those are two different ways you handle the scenario, depending on what's happening. You know, if it's your company and you're relying on you to do the presentation, let us know. You can't vote, but if you file the form, you can still do the presentation, as long as we get that beforehand. So there's different ways to do that. But it is a voting conflict. So either way you're not voting, it's just a question of whether or not you get to talk to the board or don't talk to the board. Is that okay?
Yep.
That's state law, that's not me, so just so you know, okay. The other thing I want to cover is you are required to vote. So this comes up on some of my boards. You have to vote. You cannot abstain from voting in regard to any decision, ruling, or act, and a vote shall be recorded or counted for each member. So I know we have issues with this sometimes with boards or commissions where they're like, I'm new to the board, I don't know anything, I don't want to vote. So you have to vote. But in those instances, if you're uncertain or anything, you can always make a motion to defer or to continue the item until you get your feet under you. And if that's seconded, then the item gets moved, deferred, or whatever. If that doesn't happen, you're still required to vote. It doesn't say you have to vote in the affirmative, and so if you vote in the negative, you vote. But it is, you have to vote unless you're declaring a conflict of interest. And so that's not Robert's rules. Not all boards and commissions who aren't Florida local governments have that. Sometimes you can abstain from voting, but obviously it's not meant for minor things. It really is meant for people. You have to make the decisions. You're on a board, you're on a commission, you're an elected official. You've got to make the decision. You can't just abstain for no reason at all, only if you have a conflict. And so you are required to vote. Okay. Questions on that?
Just that's all the more reason we need the corrected minutes
Understood.
ahead of time.
Understood. Understood. I'm going to pass out now. These are the bylaws, your bylaws. Everybody has a copy, Dr. Keys. Thanks. You're welcome. Mr. Olson probably already had these, probably know them by heart. Thank you. Okay. They're very short. They really mimic kind of what's in the land development code related to your board, but I wanted you to see them. I will highlight a few items. So the first paragraph, sorry. The cover item is just the resolution. This is how we approve things in the county. This is the resolution that the Board of County Commissioners approve the bylaws. Your bylaws are required to be approved by the Board of County Commissioners. You can make changes to your bylaws, but they do have to be approved by the Board of County Commissioners. The purpose is the same as it is in the Land Development Code. Article 2, I'll direct you to, is your membership. Again, 5 regular members, 2 at-large alternates. The term of service, just so you know, you're not allowed to serve more than 2 terms unless you served a partial term, and then you can go over that. Generally, you can serve longer. However, there has to be a waiver by the Board of County Commissioners. And so if you're going to go into your 3rd term, what we'll normally do is if it's the will of this body and the recommendation for somebody to serve a 3rd term, we will have to let the Board of County Commissioners know that there's a 3rd term being offered, and they would have to waive their board rules in order to allow another term.
Question?
Yes, ma'am?
Where does it describe alternates? I see a header for regular members.
So the alternate is in the Board of County Commissioner rules, and I will send you that. Yeah, well, the at-large, under membership, under establishment, it does address that there are 2 at-large alternates. Article 3 is your organization. It just talks about your chair and your vice chair who serve for 1 year. It talks about the method of election. We can go through that since that's coming up next. It's very straightforward. The chair will go first. The chair will call for any nominations. The nomination is the motion. So I nominate Ms. O'Hare. Someone would second that. The chair would ask, are there any further nominations? Somebody else can be nominated. At that point, the chair will close the nominations. Once the nominations are closed, the first person nominated is the first person to be voted upon. He would ask all in favor for Ms. O'Hare, take a voice vote, and then if Ms. O'Hare, not that she ever wouldn't, did not succeed in that vote, the next person would then be voted upon. Same process for the vice chair. The chair controls the election. Talks about duties and authorities of the chair. Just talked about term limits. No member may serve more than 2 consecutive terms. So if you were to serve more than 2 consecutive terms, it would require a waiver of the Board of County Commissioners. Going down under Article 3 on that page 4, annual reports, we talked about that, an annual report. But we're going to do the updates, but there is an annual report. Going over to Article 4, which are your meetings, the meeting schedule. So this sets forth you shall hold regular meetings on the first Monday of every other month and meet more frequently if needed. So you just had a special meeting, so that was a more frequently as needed. And you have a mandate, because that's part of being a certified local government. The board shall meet no less than 4 meetings during the calendar year. Going back to the previous conversation, under that area is quorum. So physical presence of 3 members shall constitute a quorum. Okay. Hearings, we talked about that. Requirements of a verbatim record is required to appeal. We use the tape recorder of that. Some people, if they come in here and they're sophisticated and they've done these before, they might bring a court reporter with them to make a verbatim transcript. I don't know that that's ever occurred here.
One time.
One time? Yeah. So some people know it's a contentious item, maybe up front. Not that there's ever contentious items in local government, but if they knew there was a contentious item, they may bring a court reporter to do a transcript. So there's that. At least that's what I would do if I had a controversial item. Rules of decorum, we talked about public comment, it's spelled out for you. So not only do you say that in the beginning with regard to rules of decorum and civility, and that you only have 3 minutes to speak, it's also required by your bylaws. The one thing I didn't talk about, and I'll talk really briefly on here, is the ex parte communication. That's a Florida statute. Florida statute basically says if you're having a public hearing, just like a hearing officer, I can't go to Mr. Olson was a judge in a hearing, I can't go talk to him because everybody else got to hear what we said. But the Florida statute says you can have those communications with individuals and groups as long as you disclose them on the record, and that does away with the idea of bias or prejudice. So if you have a COA or a landmark decision coming up and there's nothing against it and someone calls you up and goes, hey, I'm representing the person that owns that property, I really think you should landmark it and this is why, you'd have to disclose that conversation. And your response would be, thank you for the information. I have to hear all of it before I make my decision. Because you're not making any decisions until you've heard everything at the public hearing. But they can call you, you can have that, or you can choose not to talk to them. But that's an ex parte communication. So that's why we ask during those things if anybody's had any conversations. And that's where you would disclose them on the record. And your bylaws cover that.
Why don't you define the definition of disclose, because that's very different between different words.
So the statute helps with that. It really just has to say who you met with and so you have to say who you met with and the subject of the conversation briefly. The important part of knowing who you met with is the fact that people in opposition to that could then have the right to cross-examine that person because you've had this conversation to the extent of, well, what did you talk to Mr. Olson about, and just make sure that's information. They're going to also say, did Mr. Olson tell you anything? And he's going to say, I couldn't make any decision until I heard all the information at the public hearing, because that's what we're all going to say all the time, because that's important. Because you can't make your decision until you've heard all the information.
Quick interruption.
Absolutely.
I recall in one of our meetings recently, wasn't it clarified that a staff person is not considered ex parte?
They are not. Your staff is not ex parte. These are outside people representing the project themselves. So either opponents or proponents, applicants, local groups opposed to it, but not your staff. Your staff is there to assist you. That is not an ex parte communication.
But if you just say I had ex parte communication, you don't give any with a person and the date, but you don't give any substance of it.
That's not a disclosure. The disclosure has to be the name.
If I would drive 2 miles that way, it would be.
Okay. I'm only,
In the city, they don't ever.
really?
Yep.
I've never had that. Yeah, because I mean, if you read it, it says, site visits, written communications, and communications outside the public hearing process shall be disclosed prior to any official action on the matter, so that persons who have opinions contrary to those expressed in the ex parte communication are given reasonable opportunity to refute or respond. So yeah, I mean, I think it indicates that. And that's also true, it brings up a good point. If you get emails, obviously, do they have,
They don't have county.
they don't have county emails? So yeah, so if you are getting emails about a project, please forward those to staff.
Yep.
Those should be included in the record. And, you know, so you, in that case, you may say, you don't have to list everybody individually, but you would say, I received 6 emails in opposition, and they are part of the record.
I don't even read them. If I see who it's from.
I understand, but you still receive, I get it.
Yeah, but I
Yeah.
mean, I've been sending them, so I don't know what they're about, because I haven't read them. Just so,
Yes,
you know.
and that's a good practice, I'll be honest with you, but it's not required. So that's kind of walked you through your bylaws, very similar to what's in your land development code, which is the ordinance that created you. That sounds weird, sorry, that created the board. All right, I am done.
All right, thank you for that agenda item.
Give her a piece of candy.
My goodness, sorry, but it's good, okay.
So next on the agenda are officer elections.
Yep.
That's it back there.
The chair and vice chair shall be elected one at a time, beginning with the chair. All right. Is there any public comment regarding the chair or vice chair election?
That would not be normally a comment, a public comment.
It's
That's fine.
under number 1.
Okay.
All right. Nomination list. So let's ask for nominations for chair.
I nominate Dr. Leslie Keys for president, or not president, no, chairperson.
Any other nominations?
Point of order.
So the nomination would require a second.
Okay. So one at a time, you're right. Any second on that?
I just don't know if you're not in the running anymore, is that correct?
I am not. This was my second year
Okay.
serving.
All right, and I'm second.
Yeah. Just a point, just a question. Ms. Newman, have you acted as president, as chair?
No.
You have not?
No.
Now, as vice chair, I'm just going to mention that typically it would be, you know, you would
Right.
receive a nomination.
Right.
All right.
Yeah.
So we need to,
Well,
there was a second.
if that's the pattern, I nominate Ms. Gilman.
All right. I'll second that. So now we need to vote one at a time, correct?
Correct, so you would start with your vote for Dr. Keys.
All right.
Can the person decline a nomination?
It always becomes an interesting thing, but
Yeah.
there's no rule against declining
Okay.
it, especially if it's, you know, it makes all the sense in the world. If that's not your preference to do that, then
Yeah.
you cannot be forced to serve in a role.
So,
It's not explicitly stated, but I think it's a
Right,
matter
right,
that you
yeah,
can't be
yeah.
forced to serve in a role.
Personally, I'd rather not. I think my second term is coming this year, or the end of my second term is coming up this year.
okay.
Okay, I'm not really sure.
So you're declining?
Yes.
Okay.
Yes, yes.
So then, any other nominations? So let's vote for Dr. Leslie Keys as chair of the board. Mr. Olson,
Yes.
Ms. Jordan,
Yes.
Ms. Newman,
Yes.
Ms. Sheldrup.
Yes.
I will also vote yes, and Dr. Keys, you get a vote.
Yes.
So So the vote unanimously carries for Dr. Keys to be the next chair of the Cultural Resources Review Board.
Does the staff give?
Oh, is that from that? I think. Because they vote no.
Yeah.
Is that what you're thinking? Is that what you're thinking? Okay. All right. So the next officer election is for vice chair. And I will open up the floor for nominations.
I nominate Ms. Sheldon.
Second.
Okay, so as an alternate, she becomes a regular member?
Yes.
Okay, good. So it was actually nominated, and there was a second by Ms. Jordan.
Right.
Any other nominations?
Let me check real quick, hang on. Yeah.
Because then we would have a board of 6 if no one steps off, right?
Oh, I can take Ms. Sheldon's place.
As an alternate,
Yeah.
we'd have to vote on it. I'm sure we would. I don't know. We're looking at the rules right now.
We are.
Make up our own rules. It's like a wild
No,
stuff.
no. We're not doing that.
Even though we're in the East Coast. Feels like, well, sorry.
Okay. If you just give,
I used to live in Fort Worth, West, really good area. Fort Worth. It's better than Dallas. Just shut it down. The old saying is, Dallas. You heard that? It's got caffeine in it. There's caffeine.
They want you to apply because it's a young one.
Oh, you're saying before all
You wanna
the
inhale?
alternatives?
It's always been legal.
I don't see a prohibition against it, and we'll just have to figure out, as a matter of course, how we move back to another alternate, but I appreciate your offer, Mr. Olson. Go ahead.
I was gonna, in case you missed it, that he had volunteered to move
Yes.
to alternate.
So, go ahead.
So we should make, a motion to actually
Mhm.
have Mr. Olson.
Well, let's go, you should probably finish out your elections first.
Okay. But see, if we can't do that, then it will, that's fine. So let's go ahead and vote, the nomination has been made for Ms. Sheldrup to be vice chair, and it's been seconded by Ms. Jordan. So let's vote on it. Mr. Olson?
Yes.
Ms. Jordan?
Yes.
Ms. Newman?
Yes.
Ms. Sheldrup?
Yes.
Dr. Keys?
Yes.
And I also vote yes, so that passes unanimously. Our new vice chair is Ms. Sheldrup. So we will have to add a vote.
I can make a motion.
Yes.
Hang on.
Painfully.
So if that has to happen, let's wait, and I don't think it does. I want to wait until the next meeting, only because of district representation. And so that's another factor I have to do in there. So let me do some research on that, and if that needs to occur, then it will occur. But right now, your new chair will be Dr. Keys, and your vice chair will be Ms. Sheldrup, board member Sheldrup.
Question, does staff have the agenda for each meeting with the chair?
Staff,
The staff circulate it to the chair
And-
before it goes out.
they can. We can come up with a
So-
process for the chair.
So is that negotiable?
Yes, for sure. I'm big on sharing things before we get, making sure.
Staff prepares the agenda because they'll have the information, but yeah, normally it will be shared with the chair.
Okay. So we're saying that you're going to check the bylaws
Yes.
to make sure that.
Well, it's actually going to be more legal research than it is a bylaw, since they're silent in the matter.
Okay. All right, so agenda item number 2 is closed. And we're talking next about Florida Division of Historical Resources, special category and small matching grants, updated by Dr. Keys.
I think each of the members has a copy. And if we start on what's the back side of yours, just because it's the big kids, they are the, well, and again, a little bit ancient history, but I've been doing this for legislators since 1997 at their request. Therefore, the items that are included in the way they're included has been requested so that they can champion these through the legislative process. But that lets you see who the applications were, and obviously St. Johns County includes St. Augustine, so some of these overlap, and the ranking, and then the level of funding, because they've been only funding about 8 or 9 million a year out of, and this year there's 17 million plus, so that lets you know how far down the list they have to get to include them. I will say I was thrilled on number 2 and 4 because I wrote both of those grants for the churches. They're very leery about taking public money for churches, but the outsides of the buildings. Anyway.
So we are starting with the reader page?
Yes.
I'm sorry.
That's it. Those are the big ones. Yeah, those are the small matching grants are federal pass-throughs, so they'll probably go. The big ones, so if anybody, and I am trying to influence them, they should become familiar with these in case, you know, somebody would ask them, but not in their capacity here. Just it's a cheerlead, especially for the Hastings Museum and Civic Center. So that's to take the 2 railroad buildings near the airport, if you're on US 1 north, and twinkle our toes and levitate them, and they miraculously appear in Hastings. That lets you see what's going there. And then the small matching grants, again, they are done in rank order, dollars amounts, grant match. The lighthouse is in there for 2. City of St. Augustine has done one. It's in between the 2 lighthouse projects. So you've got the Lighthouse Heritage, Emancipation of Black Schools, the Shipwreck Survey. Then the 2 that the county submitted, Historic Property Survey of A1A, which is going to take, or the, now Jimmy Buckham, well, I had to put that one. North of the county line, south of the county line, what essentially hasn't been done before. And that's part of this came out of this board requesting that. $50,000 needed certified local government. That's why I'm so picky about making sure we live up to our CLG responsibilities, because the 10% of all the money that comes through the federal appropriation for historic preservation has to be set aside to go to state CLGs in the competitive category. And that's, I want to make sure we keep that status.
So, if I may ask, so for this, the historic preservation, the survey, when it was the southern part that we talked about.
And the northern part.
And the northern
Again,
part.
up to the county line, both directions.
Okay.
Yes.
So is this funding level, does that mean it's been approved?
It has been recommended by the Florida Historical Commission. That's why, I mean, this is the part where it'll go to delegation meetings now, and then it will go through the Florida legislative process. It's just, again, once in a great while, we will actually get a legislature that doesn't want to take federal money. So unless we get to that situation, we should be okay on those. But,
I have a question about this page.
yeah,
The Hastings Museum and Community Civic Center.
Yes.
Funding level needed 12 million plus, and the grant funds requested in the match, cash and in kind, doesn't near.
okay.
So is
It's
that
not the
project?
amount it's not the project amount. It's the funding level of the entire list. As you go down the list, based on the ranking, the project was ranked number 30.
Yes,
So
I
they
see
have to
that.
fund down through at least number 30 to pull it in to be funded. That number 30 level is 12 million and change.
Okay. that's
Not the
how much-
value of the project.
Okay, that's how much is in the overall allocation for awards.
There's 17 million total it will take for the 46, but we're only concerned to get down to 30.
Well, I still don't understand that, but everyone else understands it. I'm
No.
not gonna do
Chair,
that.
can I make a I think I understand. So the funding needed that she has listed there is additive as you go down the list of potential funding. So it says 500, the next one says 1 million, the next one says 1.5 million. I think that's what's happening is
Yeah.
that's how much money is going to need to be funded for this program for that grant to be met.
Which I think you guys got
Oh.
copies of, that you can send out to
Okay.
everybody.
So,
Okay.
So the 29, those 29 projects above it
Yeah.
Okay.
equal the 12 million.
Okay,
Yeah.
right.
There you go.
Okay.
so chances are really good that it will be funded, if there's 17 million in it.
There's 17 million requested.
Right.
Last year, the governor funded between 8 and 9. That's where it gets into what we in real life call advocacy, because none of us are paid lobbyists. Okay, and we do, but this is what again, I've been doing this for legislators as far, and what they're concerned, calling this, is providing them with information. So I hand them the list, I don't do anything else, therefore we don't have any issues, but that's the level on it. Okay, does that make
Yes,
better
thank
sense?
you.
Okay.
Thank you.
And then, again, the other ones all the way down through Hastings is, you know, 1,800,000. And again, the federal appropriation should be about 2.5 million, so all of that should come in. It's only if it gets, if somebody freezes the appropriation, because this, again, is federal money that starts dead October 1st, so as long as it gets released, it should be good. But, yeah, I mean, the nice thing is, you got a big chunk of change coming to St. John's County. So, just to make everybody aware, yeah.
So, is 2025 money already authorized and spent or appropriated?
No. The federal part has been authorized. The state will have to accept it formally. That is also part of that legislative process. So we will keep sort of hearing, like the Florida Trust for Historic Preservation will do an advocacy report, Florida Association of Museums. So there you might, other organizations that you participate with, hopefully, you'll hear as it goes through the process. I will certainly be paying attention. And then it will come out of legislative session, and then the governor has basically to the end of June to sign it. He generally waits till the last week of June to sign it, so we all sit there. My hair turns grayer. And, yeah, I hope he has a nice vacation. 50-something. So anyway, but yeah, if anybody has questions, all of that documents are public record. I go back through and I don't know whether Ryan or Megan did, I always go back through and request the ranking individual scores from all of the Florida Historical Commissioners. You can do that, the state staff will send you that real easy, real fast. And it's also got comments on, so it'll tell you what you did right and what they're particularly happy. I mean, on my churches, they got a 98 and 90. So, you know, they did great. But I've been doing this for 4 years. So, anyhow, that's the big stuff on that. The only other thing I think I put down was, and I sent this to Megan and Ryan, is I got a call from a developer who says he's buying Magic Beach, which is a culturally significant property, but not a landmark. And he wanted to hire me to help him tear it down and redevelop the property. And I told him I didn't do that. But that's just a heads up that after we went through all that effort, I know Mark Ellison signed a letter to try to keep the building that may lose it after all.
Yeah, since you brought that up, I was gonna bring it up in board member reports, and thank you for bringing it up now, because I have to be at an airport authority meeting at maybe 4 o'clock, so I don't know how long the refresher's gonna take, but I would like to, since it was brought up, has the county received a demolition permit yet for the Magic Beach motel? And if you may not.
But he did
Either
call
way.
you.
Through the chair, we did have a meeting with a prospective buyer of that property, the Magic Beach property, and so we listed all the application requirements and things that had to go through, but we have not received a demolition
Okay.
application.
If and when a demolition permit is received, is there given that there's a COA or whatever it is, we've done some form of designation.
Well, it's
for that.
culturally significant property,
Yeah.
whatever, but he can still demolish it, and you guys won't have to notify us, correct?
Actually, we would review the demolition permit application, and we would also request the applicant to provide us a mitigation plan, which would have alternatives similar to what we did with the Canwright House, and that would come before you for review.
Okay, so that was my question is will there be any kind of a stop back at CRB? if
There will-
that happens?
There will be a review process. Yeah.
Okay, so there is a stop, that will be on our agenda. And what if the demolition, we don't know, but what if he wants to and makes a case for needing to proceed with demolition, because we meet once every other month? Would that constitute a special need for a special call meeting?
It depends on what the conclusions would be, but as part of the mitigation plan, there will be a list of options there. One would be, demolition potentially with salvage, and also potentially with, interpretation of what was there. I'm thinking back to what was done previously for the same property. They had a mitigation plan. We reviewed it. The CRB also reviewed it. I think part of the alternatives was that it would be demolition with some sort of interpretation in the new building, that would interpret what was there before. Of course, that's not preserving what we wanted, but, there would be a list of alternatives,
Did you
basically.
provide him any information about the ad valorem tax exemption and the rehabilitation tax credit, so that he knows he's got financial incentives to keep it rather than tear it down?
We did mention the ad valorem tax
So I
exemption.
talked him through a lot of that, but he acted like he had no interest whatsoever. He's never done a preservation project and didn't intend to start now.
The architectural heritage of that district is really going to be severely diminished if this project goes through demolition. I mean, the reinterpretation by picking, deciding to add tail fins or whatever to a new building to try to emulate, that's not a preservation, and that's frowned upon by most architectural preservationists.
I still think your question is still open, because the question was, could there be a scenario where the prospective buyer comes in and the timing is such that we don't get to review his application for demolition?
Yeah, it would have to come before the CRB, before the county
Okay.
would actually
Okay.
approve the demolition permit.
All right, very good.
Yeah.
That's
Yeah,
yeah,
good,
thank
thank
you.
you.
All right.
Since we're talking about that, I will briefly state, though, there is one of those awkward things, I think Dr. Keyes kind of alluded to, is that having people willingly do mitigation and other things rather than demolition, or foregoing demolition, it's a balance of property rights. And so the county has to be careful on what it can impose without treading on those property rights and seeking liability for that. And, it depends on how willing they are, but generally, the way it's designated, it doesn't necessarily put any future owners on notice, and so there may be an issue with regard to just making sure that due process has been served prior to taking away property rights. And so that's just something we'll look at during the review process as well. So I don't want you to think that, they're going to have to stop whatever they're doing. It's actually a kind of a full-scale review, and we have to consider due process and the property rights as well.
But I did tell him he's not entitled to the highest and best use. He's entitled to a reasonable economic use according to the Supreme Court. U.S. Justified proportions.
I have a question. We did not designate that county landmark status, correct?
No, no.
And what was the reason behind that? Or
I thought there
could
would
we
have
do
to be
that?
acceptance by the owner.
Oh, was that it?
Generally, it's difficult to do a landmark against the owner's wishes. That's
Okay.
generally a difficult process. I don't know in this case what it was. Maybe Mr. Olson or Ryan has history on that.
Yeah, it was just that the owner did not provide an application for landmarking.
But does it have a different owner now?
I thought the ownership did change.
Yeah.
That would be part of the problem.
Yes.
The community actually raised $2 million to try to buy it, and
Right.
another guy, and I don't remember his name, sounded like he spent $4 million on it, and he's let it deteriorate. And so I don't know what Rick Johnston's proposal is to buy it, but it's in worse shape than it was 3 years ago.
Well, the basic structure is really strong because it's reinforced poured concrete.
He says it won't hold anything. And then he can't lift it, we're deteriorating it.
I am,
I'm sorry, but
your meeting.
I'm not sure he's getting good advice. I think he's got engineers that want to tear it down, and I don't think he's brought anybody in that's a preservation kind of person.
The purpose of my comment is to make everybody understand there are legal issues that would be hurdles to say you can't demolish, and so we just want to make sure that we fully understand that.
Yeah, and that's the reason I actually asked about whether we would need a special meeting, because part of what you are talking about might be, well, the CRB doesn't meet, and he'll challenge having to wait 2 months.
No, and we would, in that instance, by all means, if there was a challenge or something like that, we would simply bring it for you. I just don't know if, depending on where we end up, if it's for an actual recommendation or information or whatever, but we certainly will get it to you in a timely fashion prior to any action being taken, even if it's for awareness. We would certainly call a meeting and let you come in and understand how we got here.
And what this board would be reviewing would be mitigation efforts.
Again, it depends on what the application looks like coming to us and what the hurdles are.
Okay, thank you.
I don't mean to be a Debbie Downer, I just want to make sure everybody understands what's on the table.
In order to increase the density, what's the zoning there? Is there a zone
Well,
density?
I don't know the
They
the
can't
zoning.
have any more lodging units. They've already, because the 2 new hotels have maxed out that, and the use that goes in will have to have off-street parking.
Yeah.
So that's where they're having issues. He wants to obliterate it so we can build parking under and then build some new 2-story thing.
All right, there was one item that's still open from the meeting minutes from October 14th. That someone, I think you've reviewed the notes, are there any corrections or any
Oh,
changes to
I
be
didn't
made?
finish them, but that's fine.
Okay,
Flip through them, yeah.
so so let's vote on approval of the meeting minutes from October 14th. Mr. Olson?
Yes.
Ms. Jordan? Ms. Newman?
Yes.
Ms. Sheldrop?
Yes.
Dr. Keys?
Yes.
And yes, vote for myself. So those are accepted as they were provided, as they're approved, excuse me, as voted on. And I do need to sign that before I go, so if you could pass that down, I appreciate it. The next item is the staff cultural resource review refresher. Now, Mr. Olson, we know you have a meeting at 4 o'clock.
Yeah.
So is it here in
I've
the
got
building?
time. No, it's over at the airport.
Okay.
You can save those 2 minutes.
Wait, so you don't have to put this on the record. So you go from this board to the airport board?
Yeah, I'm on the airport authority,
You're lucky.
yeah.
He's
County
lucky.
Give me that lucky bead.
Big
He's
days.
lucky in
These
one
are big
day.
days.
You're right.
I'm not qualifying it.
You're right, you're right.
You do
This
it.
is
that
the
the
good
minutes?
meeting.
Question to Chair.
Yes.
If everyone is comfortable, this can also be postponed to the next meeting if we all feel that there are very important discussions to be had in terms of staff reports and board reports. This can wait. There is nothing too urgent if we're all comfortable with that. If anybody
How long
wants
is the presentation?
10 minutes.
10 to 15 minutes.
I think it's fine.
Yeah.
Give
Okay.
it to us now.
Okay.
If anybody is.
All right. So I want to say just one thing before I start. I am a biologist turned botanist by training. So with my background, I am very open to learning what you all have acquired through your decades of knowledge. I've been in touch with Dr. Keys about trainings through the state, through the county, through the city. I'm really trying my best to actively participate in your world. I will say, though, that this is part of my job description. So this is to serve you all so that we can all have a very open, collaborative discussion, open to critique, but at the end of the day, if there are comments to be made about my job duties, that is an HR issue. We can have them on the record, and this is an open forum. I am more than happy to speak very openly as well. So I do want to preface with that. I really admire and value how open this meeting has been. And I look forward to Dr. Keys being chair to learn from her. So to start kind of at what we call the big book, this is what we all go by. This is the third article of the LEC. We're already very familiar with this with the amendments that we proposed to inspire. This just breaks it down per section. So this is based off the Florida Historical Resources Act and a few other federal laws that enable local government to serve in this capacity. The membership procedures that was introduced via the bylaws, and so an amendment or a proposal to alter them and amend them was done in 2018 by Jan Brewer. I'm not so sure if anybody was here yet, the CRRB, I'm sure Dr. Keys was, and potentially Ms. Newman. So if anybody wants to ask me or request public record requests for those documents, more than happy to discuss that as we're interested in amending them now. County landmark designation, just the procedure behind that paperwork with the most recent example being Maricados, and then some other criteria for how the county is able to protect cultural resources as we can, what adverse effects look like here, significant cultural resource requirements, so that, as we're all familiar with, is the 50-year requirement, 50 years or older, and then the 7 criteria. And then in terms of how to protect things if they are going through processes like demolition proposals, we have HABs, and also the mitigation plan, which is synonymous with the cultural resource management plan, wherever you see that in the third article of the LDC. And so the DRM, the Development Review Manual, Section 9, that is the how-to, so how does the county actually apply this third article? The procedures for the county landmark designation through Maricados, again, you're all familiar with that type of process. A lot of paperwork. National Register nomination, the most recent example being the O'Brien Estate. Certificate of Appropriateness and how that applies to particularly county landmarks, that is reviewed in that section. Demolition of county landmarks or National Register listed properties, that will also be boldly stated. That's very unlikely, but not unheard of. And lastly, Ryan and I's favorite, super paperwork heavy, the ad valorem tax exemption. There are 3 different intricate parts, and they're all very clearly stated in this section 9.
Piece of cake.
Compared to the National Register?
So this is a lot of my bread and butter of every day. So we have lists that are generated that have different due dates, and some of these are very complex and some of them are very straightforward. Submittal management are going to be big things like commercial subdivisions, PUD, pardon me, I hear you with the acronyms, I'm going to do better at spelling things out. Planned unit development, so these are the big projects like Robinson, for instance. Interpretations of archaeological sites, so what that means and how we look at that is we get these past documents called CRAS, Cultural Resource Assessment Survey, and we have them in terms of GIS maps, and you're able to click on that to understand how it applies to that land. And just for some numbers, we reviewed almost 1,000 up until October, starting in January. And then much more simply, we have residential clearance sheets, which are basically one lot applications, things like porch renditions, replacing a pool, sometimes single home replacements if people can afford that. It is much more rare. And those are going to be much more numerous. And then lastly, demolition permits. These are the most rare, and they are typically not historic structures. They would be presented to the board if they were. They are typically residential structures, and we do verify if they have significance through the Florida Master Site File. So if they have a number attached to that residence or structure.
Yeah, and if they don't have a Florida master site file and they do meet the 50-year threshold, we do also do some research on that to determine whether or not 3 out of those 7 criteria of integrity are met. And we'll also bring that to the CRRB as well to determine significance.
You could ask them to create a Florida master site file too, even if they don't meet the 3 criteria, they can still do it.
Right, so if that unknown is there, then, they potentially would have to hire a contractor to do that, or we would do the research as well.
They're really easy.
Yeah.
So these are the resources that we use. We use GIS. Yes,
Can I
ma'am?
go back to the process? Are you the only person reviewing it at this point? Or does it go to the state as well? All the classes that come, cultural resource assessment surveys, they come in. First time I've said it.
I don't know the answer to that.
Okay.
It would be a joint review. So
Okay.
we're reviewing it as well as the consultant is sending it to the state as well, the SHPO.
Okay, so it's
Yeah.
going through SHPO as well.
Right.
Okay, thanks.
Can you go back one slide?
Here we go.
All right, that's fine. Thank you.
We're good?
So these are the resources that we use every day. We use GIS and we use 3 different types. These 2 are synonymous. Aerial and historic imagery. So those are just going to be helicopter shots throughout the years. Topography will be the layers of land, the geographic inclines or declines to understand the likelihood of archaeological sites if they have not been examined yet. Florida master site shapefile, like I said, these structures will have a number assigned to them as the site ID, forgetting the number. So if a structure does have that, we do our due diligence to understand if it is historic in the ways that they're going to be adapting the structure, if we need to present that to the board according to our bylaws. MapMart files, these are awesome. These are on the county webpage. They are publicly accessible. If we do feel like there is some discrepancy, and by that I mean if our GIS map is taking too long to load, we will go to this and do our due diligence. Archaeological model layers. So this is from a survey done in 2003 that we applied to the entire county to understand what we are looking at if we are not familiar with that area. And then cultural resource assessment survey reports. So these are going to be the type of data that we use to check what is going on under that land. We have 2 different phases really. Reconnaissance is going to be your really quick drive-by, kind of your windshield wiper. You're not breaking land or getting into the dirt. And then phase 1, 2, and 3, if they're not already completed at an area, that is a high likelihood or medium likelihood. And this is in our LBC. We do request a CRRB, so that will at least notify the developer that we are encouraging them to do some type of due diligence in the way that we can. And yet these are all different types of layers of depth into the report.
Is that required, is that a set list that's required by policy, statute, whatever?
The Land Development Code requires the phase 1 first, and what we typically use is we use the archaeological model. So if you take a vacant forested piece of property and it's either medium or high probability, then we actually require the phase 1 cultural resource assessment survey. If the conclusions of that survey are that additional work is needed, then we may have to just require a phase 2 or even a phase 3.
Well, okay, I was hoping, all right, I'm a historian here. First of all, and this, we fuss at me later, there's no such thing as vacant land.
Without a structure on it, basically.
But none of those things, for example, would pick up the Hanson Plantation 75 slaves that are probably buried on a Florida Memorial College property. But if you, that's what I'm asking because the St. Augustine Historical Society Research Library has volumes and volumes and volumes of fabulous records that the consultants never use. Just so you know. Sometimes you can contact them. If it's a slow day and they have volunteers there, they will stuff up for you. Otherwise, I really encourage you in January, when they've got everything back together again, to go to the research library and introduce yourself.
Okay, thank you.
They're enormously helpful,
Okay.
and they like to be helpful, and they really will.
Is this in Tallahassee, this research?
So now it's on Abilene Street in St. Augustine, next to the next station.
Thank you, Dr. Keys.
Yeah,
That's
they're
very helpful.
amazing records.
Is that open right now?
Not at the moment, and it's only because they did some structural work, and then they were supposed to get termite tenant, and we had Hurricane Milton, so I haven't checked with them this week. But,
I wasn't sure. Last
Yeah.
time I was down there, I made it as far as Forgotten Tonic and didn't get all the way through.
put that in the minutes, okay, she didn't get down Abilene Street very far. But there, it really is honestly one of the best
It is.
records you can, from any place you can get. It's a little tiny town, but it's got records from all the way back. Between that and Sisters of St. Joseph, we go back to 1565.
They also have an online library that's
Yes.
accessible.
Yes, so you can find out what's there, they, not necessarily everything that's in the files, which is a terrific source.
And just to add to what she said, you may want to take a copy of the predictive model that the 2003 predictive model and say, this area shows nothing. Do you have anything on your records that shows something?
Okay, thank you. So next, daily, what we explore, and maybe less daily, more so monthly or every 2 months, we're going to have questions of transfer development rights. You're probably very familiar with this, Ms. O'Hara. It is only in the Volano Beach Town Center where there are incentives to increase units if you preserve a structure. I think I said that correctly. It's a bit complex. Elimination of parking standards if it is potential that new and updated parking standards may hinder the historical significance of a structure. And lastly, ADT. We're all very familiar with this. Julie Courtney is our contact in St. Augustine. We process about 2 to 3 per year, and we do have one coming through the works, so that will be on some CRRB agenda.
Actually, CRB will not be included on that one since
Oh, okay.
their HARB is actually included. And for city AVT applications, we're basically the pass-through since it is the Board of County Commissioners that levies taxes. So they get the exemption from the board, our board.
But it doesn't go through review here because it's going through review over there.
Yeah, it's been reviewed by the HARB.
But you can put it on as an information piece, just so we know what happened.
It's just a timing issue a lot.
No,
You
I
know how it
know.
is, a lot of times we get those. Those are really time-sensitive things. And for whatever reason, they're always at the last minute. But what we're kind of realizing under our code is that since HARP does that review, it's kind of duplicative effort to have you all review it because we don't want to be in the conundrum where we have dueling boards. So, but we will bring them for information pieces, but I understand the concern.
Harvey's River, we do all the counties, till the county created this office.
Right.
Through the chair, real quick, something that we've talked about, and we'll talk about further in staff report, just I want to mention it on this point is, we do plan on reporting back to you each meeting on what we've worked on since the last meeting, and those things will come up, so you'll at least know that they occurred. They may not have a lot of detail, you might need to review, but you'll know this AVT went through for the city of St. Augustine. So it'll give you a personal heads up for your own professional advisory.
Is it, a couple of questions. Has transfer of development rights been used in any case in Volano Town Center? Has it been used?
Yes, it has.
How many times?
Just, I think one.
Okay. I guess my other question is that a tool that might save Magic Beach Motel by making that possible? I don't know, but I mean, if someone is going to build something and they can build another floor on it, even though there's generally a 3-story minimum, by saving the motel, that might be something that, I don't know, if the developer or whoever's interested, whatever, doesn't know about that possibility, they should
maybe they should explore it. But if they would only do it if they knew it was out there, it's something they could do.
Yeah, through the chair, Mr. Olson, we did mention that as a tool to assist in preservation for the Magic Beach Hotel, since that is a requirement or a provision in the Volano Beach Town Center specifically, transfer of development rights.
Who was it mentioned to the prospective purchaser?
Yeah, Mr. Johnston.
Oh,
Yeah,
okay, thank you.
sure.
And so I'm not even going to explain any of this to you all, because you all know exactly what these resources are much better than myself. These are just some of my favorite, some of the most notable in the county. And I will say that these are maintained by Parks and Rec, but if there is a change to the structure, they will be presented to you for approval or denial or commenting. So this is the ways that I've understood training in the best regard so far. So we are a CLG. That is important because we do receive funding, and they're also a very reliable monthly training avenue for me. So the DHR oversees CLG, the Division of Historical Resources. They have a wonderful website. The Department of State, they do oversee grants. Dr. Keyes presented on that. I won't get into that. And so what is very notable, I think, and important to mention here is that there are 23 historic preservation officers by training throughout the state, and there are 62 planning and building department staff throughout the state. So that is where I'm kind of in the middle in terms of my training. So I'm willing to learn and happy to learn, very excited to learn. And yeah, we just had a great meeting. It was called a Crrb session, where different CLG members across the state shared their success and horror stories. It's not funny, really, because of hurricanes, but I did learn a lot. So I'm really grateful that we are a part of that, and that does help add structure to my training. And lastly, these are the efforts that I have made, just so that people are aware that there is somebody in this role that does care and that wants to learn. I've met with FPZA, Florida Planning and Zoning Association. Mike wrote a draft for the Canright House that did win an award of Stood the Test of Time. Ryan and I worked together to write for Hastings Main Street, and they did win an award for Outstanding Public
Participation.
Thank you. I always forget that second P. Outstanding Public Participation Award. Wonderful event that night. I've met with Chuck Mead. They're doing amazing work, and I'm happy that they got some grants. City of St. Augustine Archaeological Team, so that's going to be Andrea White and Catherine Sims. Wonderful team. I can't wait to learn alongside of them whatever they're willing to share. I'm going to meet with St. Augustine Archaeological Association tomorrow. They're doing a holiday party. Tyler Smith and Dr. Kiera Lucas are wonderful contacts with DHR. I've met with Jen Lumberg to tour with Pat Hamilton the Summer Haven Matanzas area, because he is an expert. And then lastly, I'm really happy and excited to see their work in Hastings Main Street and to be a part of that. So that's everything from me. Thank you for receiving me and teaching me, and I'm excited to learn.
I'd like to add at the end of your presentation, if I may. So Megan has been a real shining star as she's come into this. So I just wanted to let you guys know that. I know there's been conversations that are questioning her role. I know it's not her specifically, but I have 100% support for the work she's doing. I think you guys can see that she's working towards the training and the understanding, and hope she doesn't have to defend that anymore, because she's working really hard and doing a great job. Thank you.
Thank you. Thank you. Are there any additional, well, let's see, are there any board reports?
The only other thing I want to be handed out is segued, it's just because we talked about the last meeting, because the job descriptions before and current. And at some point, it would be nice to know why things changed.
Pardon me?
Job description, that was changed a year ago to the current one. So everybody sees that, if we need to revise them in the future,
I don't think this board revises
it's
or does anything.
just public information.
Okay, but I'm just saying this board would not have a role in job descriptions.
All right.
Have a good time, Mr. Olson.
Any additional board reports from anyone? Okay. Any staff reports?
Yes. My apologies, this should have been an agenda item. I'm still learning how agendas work versus staff reports. So the dates for 2025, and we will email this as well, for the CRRB meetings, if everybody is ready, I will list them out.
I thought we did. Last time.
Perhaps we did. Whoa, let's start over. February 10th will be the first of the year. April 14th will be the second meeting of the year. June 9th will be the third. August 11th will be the fourth. October 13th will be the fifth. And December 8th will be the last. We also have a new commissioner as the liaison to the Board of County Commissioners. That will be Commissioner Sarah Arnold. Number 2, I did touch on that briefly in my presentation. I gave an update for the Florida Planning and Zoning Association, the different awards that went to Hastings Main Street and Can Wright House. Item 3, the DHR update. Dr. Keys did a lovely presentation on the updates of those grants. Item 4, the O'Brien Estate, this is exciting, was officially designated on the National Register of Historic Places. We did receive that letter from Dr. Kier Lucas. Item 5, we wanted to go through a few important development reviews that we thought would be applicable. And again, this is just for transparency. At this time, we don't need any type of comment. These are not action items. But I believe that in the honor of transparency, it's important to communicate to you all what I do daily, what we've been doing in the past 2 months. So demolitions, we review them for historic structure significance. If no info on that structure triggers a CRAS, the staff will conduct a review. And this was done, for example, with the Can Wright House. To prevent demolition, we went through the mitigation plan and actions were made. Second, the commercial app for snappers. There is an open comment requesting the applicant to provide more information to confirm that they are following the certificate of appropriateness as it is a county landmark. So we're basically asking for documentation purposes to confirm that the submitted construction plans and activities proposed for the project do meet that certificate of appropriateness. And that is nothing that will be done for you guys, for your eyes yet, but that is done behind the scenes.
That's what you know, as Baron Cottos and I did the historic preservation side, they are letting their engineer and their architect do the other part, so I'm not commenting on that. They have all the ad valorem text, they have everything theirs, and they have the recipe whether it be true.
Gotcha. There is a pre-application that is going through for West Church Street in West Church Street Dunkin' Donuts in Hastings. Yep, and we did ask, yeah.
And you,
Yeah.
what was the last time you mentioned?
When was the last time we mentioned it?
No, you mentioned something, you said that it did pass.
I believe so.
Oh, right.
There's an open comment. Yeah, pardon me, I should have did my due diligence there.
Ms. O'Hara, do you know?
There's an open comment to still communicate with Hastings Main Street
Yeah, I'm
representatives.
still reviewing landscape and
Okay.
plans and that kind of thing, but basically some compliance so far.
Okay. There's a pre-application for San Sebastian River Park, which is a county-owned property. It is the high likelihood of an archaeological zone. We did request a cultural resource assessment survey.
And where is that?
That is Jennifer Boulevard?
It's State Road 312 at the bridge, behind the bells there.
It's Jennifer.
Okay.
Genovar Park.
Floods all the time.
Yep. And so, I'm not sure if we mentioned this on the report, but we do also look over telecommunication towers. So there is one that is requested near St. Augustine Shores. Again, high archaeological probability in our model. So we did request a CRAS, a Cultural Resource Assessment Survey. And then lastly, notably, the detention center annex, AKA the old city jail. We are requesting a CRAS to be completed because they are requesting a demolition. So if that does follow, it will come before the CRRB.
Different old jail.
Yeah,
Different old
I
jail.
don't
We're talking
think
about the
so.
single building,
Like across the street.
Across the street from
4025.
us, not downtown.
oh,
Yeah.
Old,
An
different
actual
old
jail,
jail.
yeah.
An actual jail.
so how old is it? I mean,
Early 50s.
Yep,
Early.
51 or
so
50.
it's more than 50 years old.
But none of us would consider that old.
Right.
It's only the children.
From the
Next item is my attendance in the monthly.
Concrete block.
And barbed wire.
Yes,
Yeah.
the old
Yeah. Yeah, that's not.
concertina wire.
Sorry, go ahead.
That's all right. That's all right. It's important. It's important. The next is my attendance of the monthly CLG training. So that was, I believe, December 4th, and that was just a gripe session. So it was my understanding that maybe questions would be asked in terms of how they conduct their reviews, or, but no, it was more so about hurricane preparedness and sea level rise preparedness. Next, the CLG annual report. That is a document that we prepare to turn into the DHR. That is due at the end of December. That is due December 31st. We'll be working together to complete that. Since the time frame that we're conducting this report, it only includes my first 2 weeks of being hired. Those are the last 2 weeks of that window. So Ryan and I will be working together. Next, staff will be working with Parks and Rec on designation of the Canwright House as a county landmark. We'll be preparing that to further protect the structure. And the last item is that the Wetumpka Fruit Company, there was what's the correct terminology?
State marker.
Thank you, state marker. That was erected, that was erected at the intersection of Leonard and Hastings, or is proposed to be erected?
Soon to be
Okay.
erected, yeah.
Thank you, Mike, and we'll pass that around, the paperwork for that.
And
It's
you're
a
gonna,
historic state marker. They don't usually come through you. It's a state program, not a county program.
So we don't put another marker up for the county.
Yeah.
no, and actually,
Our involvement usually is if it's in the right of way, we have to give permission to put it in our right of way.
or if the county's sponsoring it.
Right.
Yeah, I was gonna say that.
I don't think did we sponsor Wetumpka?
We did not
No,
sponsor
we did
this one.
not.
did-
I think they had to get a right of way permit from us or something like that.
But, yeah, it's good to know, just to have that information, know what the markers say, so if you get that would just,
It's there.
It's coming around.
It's coming around.
but I mean, just, and then I assume that you're gonna send us a copy of that annual report presented.
For sure.
Yeah, I saw this.
I have a question for OCA. Do we have to have them, the members vote on the meeting, the future meeting dates? Does
No.
that have to be a vote? Okay.
Just useless trivia, the county sponsored the Evergreen Cemetery marker years ago, and it was wrong, so I actually got it correct.
So you could take this with you.
Yeah.
Okay, so
I'm sorry, Stacy's cousin.
you can read all that? Yeah, you bet.
I grade student papers, are you kidding me?
Yeah, generally on the markers, those, the language comes to us, depends on if we're sponsoring, but even when we sponsor, it usually at the behest of a different organization, so.
Well,
They
have
can come
done
to us
better than-
all times, all sorts.
I'd be interested to see what you put together for Canwright to be a landmark. Certainly not, since it's been moved. And it's certainly got an interesting interior now. Let's just put it that way.
So you're asking for the description that we submitted, you mean? For that little award?
No, for the
the
landmark.
county landmark designation
Oh, I'm
report,
sorry, I
I think
didn't-
will be entertaining to read.
No pressure.
Yeah.
I'm always leery of
Any other?
park people doing preservation.
I have one more bit of staff, just to mention, this is actually Ms. Sheldrop's suggestion of reviewing the tally as we go forward was a little more detailed, but we had actually, we met with Dr. Keith actually a couple weeks ago and started talking about the idea that some of y'all's expertise and the reason you're on this board is to advise on certain projects. And there was an understanding, for instance, with the meeting with the comp plan, that maybe you guys didn't know exactly what we were doing and how that work was going. And so what we realized is we need to toot our own horn a little more, which is what Megan was doing. So all of those reviews that we're going through, there's not always something that the cultural resource staff has to apply expertise to, but we still have to review them. So you saw thousands, literally thousands of data points coming through. Is this something? Is this not? Is this not? But what we do want to do is recognize that you guys are on this board as volunteers, as experts, as advisors for the County Commission. And so before your suggestion, we had made a commitment to come to you every meeting with what we had worked on in the last period. We don't want to go through the last 10 years that you don't have that, because that would just take too long. But starting now, by the next meeting, you'll know everything that comes across our desk that has to do with cultural resources. You won't always get a chance to comment on something that you have specific knowledge of. Dr. Keys talked about the Hanson, will you refresh me?
Plantation. Yeah.
Hanson Plantation. She brought that up in our meeting, and that specific example was great because she has knowledge about that issue that maybe we don't. And she knows where you can find knowledge about that issue that maybe we don't. And that's a great role for you guys to say, hey, there's something else to look at. So when we come back to you and we bring back this list of 50 or so reports, like, we're not going to go through them in a detailed way, but I encourage you to go through them in a detailed way and say, oh, this one, and we'll get them to you before the meeting, this one I have knowledge of, and here's something maybe you haven't considered. That's something that we can act on. But if we don't know it exists, then we can't act on it. Does that make sense? Like, we just don't know everything that you guys do. So we're hoping that will result in a flow of information that's not just, here's what staff did, and you guys saying, okay, great, move on. Here's what staff did. Oh, there's a potential for this other thing here. Maybe you can go look at this site, or I have this information already collected and I can share it with you. And that can incorporate into the review going forward, because just because it's come across our desk doesn't mean it's done. Does that make sense? And please correct me if I'm advising incorrectly here, but the idea is once your expertise once you have a chance to see it, hopefully you'll say, okay, here's something that you might have missed, and we're totally open to that. And that's a great, I think, communication and dialogue between staff and you guys in your roles. So I just want to say that, like, that we're hoping that will work, and we'll also add to that kind of a reporting back on some of these other items that you suggested. So thank you.
And I've sent whatever you want that I think you don't already have on Hanson. I've got a ton of stuff, Christine.
My only
Remember that stuff, too.
cautionary tale always remains that the flow of communication outside of a notice public meeting needs to be one way. And so that's fine if you're communicating with staff, but as a board as a whole, again, you can only communicate regarding things that might come before you, and I think it gets a little bit gray, so we try to just say all matters through a notice public meeting. So I think, though, if you're sending out a report or whatever, 2 weeks, a month before the board, whenever, and those items are on it, and you identify something that you have information or knowledge on, by all means, communicate that to staff, but do not reply all. And then at the meeting is your opportunity to then say, based on that report we sent, Dr. Key sent us information, we followed up on that information, or you can wait to the meeting and say, here's some additional thoughts I have, and share with the group. That's my only caution as the attorney, is to make sure of the flow of information doesn't violate sunshine laws.
But they could communicate directly to us,
Yes.
for instance, right?
Yes.
Yeah, and one thing we've started, Keely, just so you miss, is we've asked our staff, we only reply with everyone in the BCC, so there's no chance of replying to all on accident. You know what I'm saying? So that's just a practice I had in the past life.
Very good.
And everybody's got copies of the St. Augustine Beach Hotel National Register nomination. Yes. No. All right, I'll be on the record, I'm sending it to the staff to send out. You'll see why the ad valorem is so much easier now than a National Register. It's like writing a master's thesis.
Oh, yeah.
55 pages, single-spaced.
I've been involved in numerous ones.
I'm not kidding.
That, folks, is called a historian flex.
No, that is, well, it's
Any other items?
bureaucracy flex.
I did want to mention, since Dr. Keys brought it up, that we do have our wrong local government. Our St. Johns County delegation meeting was on January 10th.
Thank you.
Mark,
I've been asking.
yep, January 10th is the delegation meeting for all you who don't know that, because that went, our Florida senators and representatives, they come and hold a meeting in the area, the local government, the county, which they serve, and they hear, this is not the Board of County Commissioners, this is really an opportunity to come speak to them directly. There's a process where you can fill out a card so they know ahead of time. Your 3 minutes or whatever, you go advocate, as Dr. Pease likes to say, for whatever it is you want to advocate for, Alzheimer's Association, historic properties, whatever it is, I've done it all. And so you get to go speak to them.
What time and where?
It's in the chambers, and we will let you know what time. I imagine it's starting at 9 a.m. or 10 a.m., but I will let you know. Usually it's from 9 to noon.
It's Friday the 10th.
It's usually from 9 to noon or something like that, but we will certainly, I will give that to staff and they will send it out to you. And also the process to sign up for that, because generally that's just, they like to know ahead of time so they can have time available. So whether it's a speaker card or a form you fill out, but we will certainly get you that information.
And for those who remember Shorty Robbins, and hopefully nearly all of you do, she is Justin Sapp's aide now. So that's, I'm quite familiar with that.
One last comment, word of encouragement, or at least information, at the December 5th meeting, if you go back and watch, early in the meeting, the comp plan consultant did report back, and if you haven't seen that, a lot of what you guys had said made it into that presentation. I just wanted to let you know that that's occurred.
That's the PZA.
Was it PZA?
Yeah.
Yeah, it was a PZA meeting,
December
I'm sorry.
5th was the PZA, not the BOCC.
I apologize
That's on
for
the
that.
3rd. That's okay.
The BOCC's in January then?
Yes, it's moved down. We have a new Board of County Commissioners, we have 2 new members, and so settling in.
So, yeah.
Very good.
And the last thing relates to Sarah, by the way. America 250, which you may not have heard of. Anyway, it's the America's 250th anniversary. The governor did finally appoint a commission. We were one of only 6 states that didn't have one. So, anyway. So think about all that history stuff.
Commissioner Arnold would have been here. She sends her regrets, but she is available if you ever need to reach out to her. She will be at a meeting in the near future.
Ms. Newman, did you have?
Oh, I was just going to ask you quick, that I can figure it out.
Sure.
December
The date-
5th, December 5th, PZA meeting.
PZA.
Sorry about that, thank you.
Figure it out. Thank you.
Okay, and with that, it is now 3:47 on December 9th, and we will adjourn today's meeting for the Cultural Resources Review Board. Thank you.
Thank you.